vehicle! Hands where I can see them!
Officer, my identification is in my breast pocket. I am a member of the federal judiciary.
And I'm the King of England. Shut up and get on the curb.
Officer Vance, badge number. You are about to make a career-ending mistake.
What Officer Tyler Vance didn't know was that in the next 11 minutes, his routine patrol stop would transform into a federal incident that would cost the city of New Orleans $6.4 million, end his career in law enforcement, and send him to federal prison for 4 years. The man he had just slammed against the Mercedes wasn't a car thief. He was the Honorable Elias Thorne, a United States District Judge for the Eastern District of Louisiana, a man whose signature could destroy entire criminal enterprises with a single motion to dismiss. This was Tuesday, June 18th, 2024, at approximately 7:43 p.m. in the parking lot of Starlight Market, an upscale grocery store in the Garden District where the average household income exceeds $240,000. Judge Thorne had just finished his weekly shopping trip, a ritual he had maintained for 15 years despite his ascension to the federal bench. He preferred anonymity, the simple act of selecting his own produce, the normalcy of pushing a cart through fluorescent-lit aisles. He was a ghost in his own city, a federal official who still wore sweatpants to buy eggs. Elias Thorne's story begins 43 miles upriver in the 10th ward of New Orleans, a neighborhood where survival is an art form and opportunity is a foreign concept. Born in 1970 to Loretta Thorne, a single mother who cleaned offices at night, emptied bedpans at a nursing home during the day, and sold hand-sewn quilts on weekends, Elias learned early that excellence was not optional. Loretta worked 3 jobs to keep her son in a pressed white shirt for Sunday service at Greater Bethlehem Baptist Church. She saved for 7 years to buy him a used set of encyclopedias. When Hurricane Betsy knocked out power for 2 weeks in 1975, 5-year-old Elias studied multiplication tables by candlelight, his mother quizzing him between shifts. "You will not be ordinary," Loretta would whisper as she kissed his forehead each night. "You will be extraordinary." And so he was. Elias graduated valedictorian from Frederick Douglass High School in 1988 with a perfect GPA and a full academic scholarship to Harvard College. At Harvard, he was an anomaly, a young black man from the Deep South navigating the ivy-draped halls of Cambridge with the same quiet determination that had carried him out of the 10th Ward. He majored in government, minored in African American studies, and spent his summers interning at the Southern Poverty Law Center. In 1992, he entered Harvard Law School. 3 years later, he graduated magna cum laude and returned to Louisiana, not to chase corporate riches in Manhattan, but to fight for those who couldn't afford a lawyer. For a decade, Elias Thorne was a civil rights attorney who made powerful people uncomfortable. He represented victims of police brutality, families of inmates who died in Louisiana's notoriously brutal prison system, and workers subjected to wage theft. He won settlements that forced municipalities to reform. He deposed sheriffs who perjured themselves. He was relentless, methodical, and uncompromising. In 2005, he joined the U.S. Attorney's Office as a federal prosecutor, where his focus shifted to public corruption and civil rights crimes. He put away dirty cops, corrupt judges, and elected officials who treated public funds as personal piggy banks. By 2016, Elias Thorne had earned a reputation as a legal surgeon, precise, unemotional, and devastatingly effective. When President Barack Obama nominated him for a seat on the United States District Court for the Eastern District of Louisiana in 2017, the Senate confirmed him 89-7. At 47, Judge Thorne was one of the youngest federal judges in the country. Loretta Thorne sat in the front row of his investiture ceremony, tears streaming down her face as her son took the oath. She had cleaned toilets so he could wear a robe. He had made her sacrifice worth it. Now, 7 years later, that same man stood in handcuffs in a grocery store parking lot, accused of stealing his own car. Officer Tyler Vance, a 7-year veteran of the New Orleans Police Department with a personnel file groaning under the weight of 17 use-of-force complaints, all cleared by internal affairs, had made an assumption. Vance had been patrolling the Garden District, an affluent neighborhood of antebellum mansions and manicured lawns, when he spotted Judge Thorne placing bags into the trunk of a 1987 Mercedes-Benz 560 SL. The car was a classic, cherry red, immaculate. The man loading it was black, wearing athletic clothing. Vance's brain performed the racial calculus that has destroyed countless lives. Black man plus expensive car plus affluent neighborhood equals crime. He never considered that the man might own the car. He never noticed the keys in Thorne's hand. He never saw the receipt clutched in the judge's other hand. Vance saw what his biases told him to see, and so he acted. "Step away from the vehicle," Vance barked as he exited his patrol car. Judge Thorne, holding a carton of organic eggs and a bag of arugula, turned calmly. "Good evening, officer. Is there a problem?" His tone was measured, the voice of a man accustomed to de-escalating tense situations in his courtroom. Vance's hand moved to his holster. "I said step away from the vehicle. Now." Witnesses would later testify that the judge complied immediately, setting the groceries on the ground with deliberate slowness. "Officer, I am the owner of this vehicle. My credentials are in my breast pocket. May I retrieve them?" Vance closed the distance between them in 3 aggressive strides. "You match the description of a suspect in a vehicle burglary. Hands on the car, now." My mother told me stories like this would never reach anyone. She said people like Judge Thorne would always be treated as suspects first, citizens second. But you're here, watching this, proving her wrong. This is why this channel exists. If you believe that no badge should be a license to humiliate, hit that subscribe button right now. Because what happens next will shock you, but it needs to be seen. Judge Thorne placed his hands on the roof of the Mercedes. "Officer, I am informing you that I am a United States District Judge. My identification is in my breast pocket. There has been a misunderstanding." Vance ignored him. In one violent motion, he yanked Thorne's left arm behind his back. The judge gasped. Vance wrenched the second arm behind him and slapped on handcuffs with enough force to leave bruises that would be photographed by the FBI 3 hours later. "You're under arrest for vehicle burglary and resisting an officer," Vance announced. A crowd was forming. An elderly white woman in a Chanel jacket approached. "Officer, that's Judge Thorne. He shops here every Tuesday." Vance waved her off. "Ma'am, step back. This is police business." The store manager, a man named Marcus Chen, rushed out with security footage cued on his tablet. "Officer, this is a misunderstanding. Judge Thorne is a regular customer. I can show you footage of him entering the store 20 minutes ago." Vance refused to look at the screen. He shoved Judge Thorne toward the patrol car. It was at this moment that Vance's partner, a rookie named Officer Daniels, finally spoke. "Vance, maybe we should check his ID." Vance whirled on him. "Are you questioning me?" Daniels went silent. He would later testify that he knew the stop was wrong but was too afraid to intervene. This silence would cost him his badge. The Fourth Amendment to the United States Constitution protects citizens from unreasonable searches and seizures. It requires that any arrest be supported by probable cause, a reasonable belief, based on specific facts, that a crime has been committed. Officer Vance had no such facts. He had a man loading groceries into a car he owned. The Supreme Court case of Terry versus Ohio established that police may conduct brief investigatory stops if they possess reasonable, articulable suspicion of criminal activity. Vance's suspicion was neither reasonable nor articulable. It was racial profiling dressed in a uniform. As Judge Thorne sat in the back of the patrol car, hands cuffed behind his back, he did something that would later be described by federal prosecutors as textbook advocacy under duress. He remained calm. He did not raise his voice. He repeated clearly and slowly, "Officer Vance, you are violating my Fourth Amendment rights. You have arrested me without probable cause. I am a sitting federal judge. My identification is in my breast pocket. I am requesting that you verify my identity immediately." Vance's response was chilling. "I don't care if you're the Pope. You're going to jail." At 7:54 p.m., 11 minutes after the initial contact, a supervisor arrived. Sergeant Linda Hawthorne took one look at the man in the back of the patrol car and felt her stomach drop. She knew Judge Thorne. 2 years earlier, he had presided over a federal trial where her husband, also a police officer, had testified. "Vance, what the hell have you done?" she whispered. Vance, still convinced of his righteousness, explained that he had arrested a suspected car thief. Hawthorne opened the patrol car door, her face pale. "Your Honor, I am so sorry. There has been a terrible mistake." Judge Thorne's expression did not change. "Sergeant Hawthorne, I will need your body camera footage, Officer Vance's body camera footage, and the CAD report for this incident. I will also need the names and badge numbers of every officer on scene." His voice was ice. Vance's body camera told a damning story, or rather, it didn't. Despite departmental policy requiring activation at the start of any citizen contact, Vance's camera didn't turn on until after Judge Thorne was already in the car. The first 8 minutes of the encounter, the most critical minutes, were undocumented. This was no accident. If this story is making you angry, good. That means you still believe the system can change. But anger without action is just noise. Leave a comment below telling me what reform you want to see. Let's build something together. And share this video, because the algorithm buries stories like this unless you fight for them. Judge Thorne was released at the scene with an apology. He drove home in silence. The carton of eggs cracked, the arugula wilted. He sat in his study until 3 a.m., drafting a single email to the most prestigious civil rights law firm in the South, Robichaux and Associates. The firm's founding partner, Claudette Robichaux, had argued before the Supreme Court 6 times. She took the case within an hour of reading Thorne's email. The lawsuit, filed in federal court 3 weeks later, was a legal missile. It named Officer Vance, Officer Daniels, Sergeant Hawthorne for failure to supervise, and the city of New Orleans as defendants. The complaint was 47 pages of surgical precision, outlining each constitutional violation with case law citations that read like a prosecutor's closing argument. Count 1, violation of the Fourth Amendment, unreasonable seizure and false arrest without probable cause. Count 2, violation of 42 U.S.C., paragraph 1983, deprivation of civil rights under color of law. Count 3, violation of 18 U.S.C., paragraph 242, criminal deprivation of rights under color of law. Count 4, negligent training and supervision by the City of New Orleans. Count 5, intentional infliction of emotional distress. The lawsuit demanded $10 million in compensatory damages, $5 million in punitive damages, and an injunction requiring sweeping police reforms. The complaint included a devastating detail. This was Officer Vance's 18th use of force incident in 7 years, and all 17 previous complaints had been cleared by internal affairs. The system hadn't failed. The system had been designed to protect officers like Vance. The Department of Justice doesn't move quickly, but when it does, it moves like a glacier, slow, inevitable, crushing. Within 72 hours of the lawsuit being filed, the DOJ's Civil Rights Division opened a concurrent criminal investigation into Officer Tyler Vance. Federal agents interviewed the witnesses from the Starlight Market parking lot. They subpoenaed Vance's entire personnel file. They discovered a pattern of investigatory stops in affluent neighborhoods, 87% of which involved people of color, and 91% of which resulted in no arrests or citations. This was racial profiling masquerading as policing. The case attracted national attention. Civil rights organizations held rallies outside New Orleans City Hall. Editorial boards called for accountability. The video footage from the store's security cameras, showing a calm, cooperative Judge Thorne being violently handcuffed, was played on every major news network. The city of New Orleans found itself in an impossible position. If the case went to trial, the discovery process would expose decades of systemic failures. Internal affairs reports would be made public. Training records would be scrutinized. The dirty laundry of an entire police department would be aired in a federal courtroom presided over by one of Judge Thorne's colleagues. The city blinked. 7 days before the scheduled trial date, after a week of mediation, the parties reached a settlement. The city of New Orleans agreed to pay Judge Elias Thorne $6.4 million. The settlement was one of the largest in the city's history for a single incident of police misconduct. But Judge Thorne didn't want just money, he wanted change. The settlement included a consent decree mandating sweeping reforms. Officer Tyler Vance's dissent was swift and absolute. The day the settlement was announced, he was terminated from the New Orleans Police Department for gross misconduct. The Louisiana Peace Officer Standards and Training Council revoked his post-certification, ensuring he could never work in law enforcement again anywhere in the state. His pension, earned over 7 years, was forfeited. Federal prosecutors, armed with evidence of a civil rights violation, convened a grand jury. Vance was indicted under 18 U.S.C. paragraph 242, deprivation of rights under color of law. In March 2025, after a 4-day trial in federal court, a jury deliberated for 90 minutes before returning a guilty verdict. Judge Thorne recused himself from the case, but he attended every day of the trial, sitting in the back row of the gallery, a silent presence. At sentencing, the federal judge handling the case delivered a scathing rebuke. Officer Vance, you were given a badge and a gun and the public's trust. You weaponized that trust to humiliate a man whose only crime was existing while black in an affluent neighborhood. This court sentences you to 4 years in federal prison. Vance is currently serving his sentence at a federal facility in Texas, far from Louisiana, for his own safety. He will be 39 when he is released. He will never wear a badge again. Officer Daniels, the rookie who stood by and watched, was fired for failure to intervene, though he faced no criminal charges. Sergeant Hawthorne was demoted and reassigned to administrative duties. She retired 6 months later. But the real legacy of the Thorne incident is not measured in prison time or settlement dollars. It's measured in policy. The settlement mandated the creation of the Judicial Oversight and Transparency Act, a municipal reform package that fundamentally restructured police accountability in New Orleans. The reforms include 3 critical components. First, the duty to identify protocol. Officers must immediately acknowledge and verify any professional credentials presented during a stop. Failure to do so is grounds for disciplinary action. Second, the kill switch body cam law. Any officer who fails to activate their body camera during a citizen contact faces an automatic 30-day unpaid suspension. A second offense results in termination. There are no exceptions. This law has teeth because it removes discretion from police administrators who historically protected bad cops. Third, the Civilian Accountability Board, an independent board with subpoena power composed of community members, retired judges, and civil rights attorneys, now oversees all police misconduct investigations. Internal Affairs no longer investigates itself. These reforms have been adopted by 6 other Louisiana municipalities and are being considered in 4 additional states. The Thorne incident became a case study in police academies across the country, a cautionary tale titled The $6.4 Million Stop. Judge Elias Thorne still shops at Starlight Market every Tuesday. He still wears his Howard University hoodie and sweatpants. But now, when he loads groceries into his Mercedes, off-duty officers nod respectfully as they pass. The manager, Marcus Chen, named a sandwich after him, The Honorable, made with arugula, organic eggs, and a side of justice. Loretta Thorne, now 78, keeps a framed copy of the settlement agreement in her living room next to her son's Harvard diploma and his investiture photo. She still can't believe that the little boy who studied by candlelight grew up to dismantle a corrupt system with a single lawsuit. When asked about the incident, Judge Thorne is characteristically measured. What happened to me happens to countless people every day. The difference is I had the resources, the legal knowledge, and the platform to fight back. Most people don't. That's why these reforms matter. That's why accountability matters. Officer Vance's story ends in a Texas prison. Judge Thorne's story continues on the federal bench, where he presides over cases with the same quiet authority, the same razor-sharp legal mind, and the same unwavering commitment to justice that he has carried since his mother first whispered, "You will be extraordinary." The Thorne incident is a reminder that the arc of the moral universe is long, but it bends toward justice only when people refuse to be silent, refuse to be complicit, and refuse to accept that a badge is a license to oppress. It bends when a man in a Howard hoodie holding a carton of eggs looks a corrupt cop in the eye and says, "You're about to make a career-ending mistake." And it bends when 6.4 million and 4 years in federal prison send a message that accountability is not optional. It's the law.